volume's not up.
All right, good afternoon, everyone. Let's go ahead and get started. This is the state expedited accusations calendar. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney here at this proceeding. All participants, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this particular proceeding. Ms. Grace, what is my reset date?
12/8, Judge.
Okay. All right. All those who receive a surety or a cash bond today will be reset to the state all-purpose calendar on December the 8th. Those who receive a signature bond, whether through the jail or pretrial, will be reset further notice. Who do we have first?
Good afternoon, Your Honor. We have position number one, Mr. Raymond Moran.
All right, good afternoon, Mr. Moran. I'm Judge Melanie Williams. Do you understand those rights that I just read?
Yes, Your Honor.
All right, your case number is 22 CR 007960A. In this case, you're charged with simple battery against either a police officer, a corrections officer, or a police dog with the offense date of November the 25th. Ms. Harrison, can I have his history, please?
Judge, GCIC indicates no prior history, and he does meet the criteria for UJR. Nothing further.
All right, thank you. Whose case is this for the state?
Your Honor, Alexis Guidry on behalf of the state.
Good afternoon, Ms. Guidry, please proceed.
Yes, Your Honor, this is Raymond Barrett. He's currently charged with simple battery against an officer with no bond. This is his first arrest. However, the state is requesting a $3,000 surety bond, no further contact with Sergeant Starks, a stay away from 240 Peachtree Street, Northwest Atlanta, that is Wells Fargo, and no alcohol, drugs, or weapons. Your Honor, state tends to prove that on November 25th of 2022, last year, officers responded to Wells Fargo. The officer stated that he was escorting the defendant out of the bank when the defendant struck him in the face with an open hand, lending him charging with this charge of simple battery against an officer. We do understand that this is his first arrest. However, given the nature of the charge and it being against an officer, we are requesting a $3,000 surety bond and that he stay away from that Wells Fargo.
All right, thank you. And someone is unmuted. Please mute if you're not speaking. All right, who represents the defendant?
Good afternoon, Your Honor. Good to see you. That is my case. Can y'all hear me? This is the first time using Zoom on this laptop.
Yes, we can hear you. Go ahead, Mr. Bartels. Good to see you.
Okay, thank you, Your Honor. Yes, I have spoken with Mr. Moran. As pretrial indicated, this is his first arrest. He is 23 years old with no criminal history. He does dispute certain allegations in this case, especially some of the facts leading up to this. He said that he was actually initially assaulted by the alleged victim who was working security at this bank. I have advised him that there would be a no contact order and that he would need to do whatever banking he has or stay away from that location or do his banking online. And he certainly indicates that he can do that. He is going to school full-time, Your Honor, at Georgia State. He does live on campus. That's the Cortlandt Street address. That is student housing. And I did verify that. He indicates that he is going to Georgia State full-time and is studying finance. And so he does have ties to the community. And given all that, we would ask the court for an unsecured judicial release.
All right, at this time, the defendant will receive a $5,000 signature bond through pretrial services. He is to take the one-day anger awareness course. He is to stay away from the Wells Fargo location on Peachtree Street and have no contact with the officer involved in this case. He is also to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing from defense, Your Honor. Thank you.
Nothing from the state.
All right, best of luck to you, sir. Who do we have next?
We have position number 2, Mr. Cedric Kane.
All right, good afternoon, Mr. Cade. Your case number is 22 CR 007965C. In this case, you're charged with 2 counts of criminal trespass with the offense date of November the 25th. You understand your rights?
Amen.
All right, Ms. Harrison.
Mr. Judge, GCIC indicates 28 cycles. Last arrest was December of 2020 for arson, 2nd degree. Record indicates the defendant is currently on probation for arson. That is out of DeKalb County. Case number B as in David 0283119, sentenced September of 2022, 6 years probation. And that is, he actually has two counts. So he has 2 counts of arson and criminal damage to property. They're to run concurrent with the arson in 2nd degree. Record indicates an additional open probation for aggravated assault, 2 counts out of DeKalb. It is first offenders, sentenced to 10 years, 18 months to serve. Additional open probation out of Fulton County, case 12 SC 114564, sentenced May of 2013, 2 years confinement, 8 years probation. Record indicates 4 violations of probation within the past 10 years.
No,
Case 2000.
All right, thank you, Ms. Harrison. All right, whose case is this for the state? Oh, Ms. Williams, please proceed.
Yes, good morning, Your Honor. Miracle Williams for the state. The state is recommending in this case, on the first count of criminal trespass, an $8,000 good bond with no further contact with Marilyn Harris, and a stay away from 555 Lake Drive in Hateville, Georgia. And also the exact same $8,000 good bond and stay away, no further contact on the second count as well, Your Honor. In this case, Your Honor, the Hateville Police Officer Workman responded to the location regarding a complaint by Miss Marilyn Harris, who initially advised that the subject would not leave and he possibly had a knife on him. She further advised the officer that the defendant subsequently slashed her tires and busted the window out as well. Upon speaking with the defendant, Officer Workman advised that the defendant did admit to slashing the tires and busting a window. And he advised because she had her grandson to try to jump on him. Reason being because he dressed well. That's what he advised the officer of. As stated, Your Honor, he does have 28 cycles, multiple probation violations, with the most recent being 2020 on record. He does have a conviction for aggravated battery in DeKalb, another conviction for criminal damage to property in the 2nd degree. There's multiple criminal trespass arrests in 2016, 2017, 2018, and 2019. He was actually just sentenced less than 2 months ago on the arson charge and 2 additional counts of felony criminal damage to property in the 2nd degree. Again, that was just recently sentenced less than two months ago. He does have a very high likelihood of reoffense, Your Honor. So we would ask for a $8,000 good bond on both counts, as well as a no further contact with Marilyn Harris and a stay away from the incident location.
Okay. You're asking for 16,000 total?
Yes.
All right, thank you. Mr. Martellus, please proceed.
Well, Your Honor, I attempted to discuss the case of Mr. Cade. He declined to discuss his case with me, so I take it from that he wishes to represent himself.
So, Mr. Cade, you're declining the services of the Public Defender's Office And you wish for me to set a bond for you pro se? Is that what your wish is today?
I said I was asking for a signature bond because I got a criminal trespass.
Wait, no, we're not getting to that point. We're not getting to that point. Stop talking, Mr. K. I do not want you to incriminate yourself. You have a right to remain silent. My question is, do you want Mr. Bartels to
I know I
represent?
did. I know I bust something window.
Okay, please stop talking, please. Do you want Mr. Bartels to represent you? Yes or no? The Public Defender's Office, would you like him to
No.
represent?
That's why I want public defender. I ain't got no paid lawyer.
Right, and Mr. Bartels says that he was willing to represent you, but you didn't want to speak with him. Do you wish to have him represent you now?
Yes, ma'am, for real.
Okay, now, Mr. Bartels, do you have the entire calendar?
No, Your Honor. I just have number 2 and number 3. So Ms. Armstrong has the rest of the calendar. If I could.
Can you give the jail a call since now he wants your assistance? And can
Absolutely,
we go
Your Honor.
other than I'm going to remember so we don't have to go back to Ms. Williams. Ms. Williams is requesting an $8,000 surety on each count. Mr. Bartels, if you give the jail a call, and can we go to a position?
Okay, can somebody text me the number?
Mr. Bartell, he's gonna have to go to the end of the calendar because he speaks extremely loud and it will disrupt the court.
I'm saying, cause I ain't.
This is what we're gonna have to deal with.
Okay. What is the extension there? Could somebody just text, could somebody give it to me in the chat room?
I'll give you the extension in the chat room, but we're gonna do this at the end of the calendar.
Yes, sir. All right, thank you.
Thank you. Hey, those should be back on the next one.
All right.
Next, we're gonna go to position number 5 and add on 1. And it's gonna be Keith Oliver.
Okay, I'm sorry, I was not aware that add on. All right, Mr. Oliver, good afternoon. You have 2 cases on this calendar today. The case number that I see on the add-on calendar has the same case number that appears on the original calendar. Is that correct? Does anyone from this, Ms. Williams, are you aware the number that I see on the add-on is 22 CR 007964C? That's the same number that appears on the calendar at position 5. Is that correct?
The other, Your Honor, should be 22 CR 007962.
2C. Okay, that's not the add-on calendar that was sent to me. All right, Mr. Oliver, you have 2 cases. In the case ending in 2C, Ms. Williams, is that charged theft by taking as well?
It is, Your Honor, as well as criminal trespass.
All right, so in the case number ending in 9224C, Mr. Oliver, you're charged with 1 count of theft by taking and 1 count of criminal trespass. In case number 22 CR 007964C, you're charged with 1 count of theft by taking with the offense date of January the 11th. Do you understand your rights today?
Yes, ma'am.
All right, thank you. Ms. Harrison?
Yes, Judge, 13 cycles, last arrest, September of 2021 for probation violation in Fulton County. Underlying charge was not indicated. Record does indicate the defendant has an open case pending for theft by receiving stolen property, 22 CR 005760C. That case is currently in dormant bench warrant status. Also, the defendant appeared in first appearance today under case 22 CP 214245 for theft by taking, possession of tools, and criminal trespass. He was given a $20,000 good bond. Record indicates 7 violations of probation within the past 10 years. In 2018, misdemeanor conviction, theft by shoplifting, 2 counts. A 2020 felony conviction for theft by taking and burglary in Cobb County. Nothing further.
Thank you. All right, Ms. Williams, please proceed.
Thank you, Your Honor. In the first case, 22 CR 007964C, we are asking for a $20,000 good bond. And in the 22 CR 007962C, we're asking for a $20,000 good bond on the theft by taking and a $10,000 good bond on the criminal trespass. In the 62C case, Your Honor, on December 4th of 2021, Georgia Tech Police Detective Underwood observed the defendant walk from the rear of Kappa Alpha fraternity house through Christian Campus Fellowship parking lot on the Georgia Tech campus with a black Raleigh mountain bike owned by and taken from Andrew Depp. The defendant was observed riding the bike through campus heading toward Northside Drive while already being criminally trespassed from Georgia Tech. In the subsequent case, which was approximately a month later on January 11th of 2022, the defendant was observed on camera by Georgia Tech police walking away with a black Schwinn bicycle with black leather wrapped handles belonging to and reported stolen by victim Michael Davis on the campus of Georgia Tech. Your Honor, I think it's important to note that there was a previous stay away in place with Georgia Tech for 5 years that has not expired. It was not to expire until December of 2022. And this is the result of a conviction with Superior Court under 17 SC 150278, where on February 2nd, 2017, defendant stole a bike from Matthew Egan from the main entrance of Georgia Tech campus. On February 9th of 2017, defendant stole a bike from Joshua Crisp from the bike rack on Georgia Tech's campus. On February 13th of 2017, same situation, stolen from Ashwin Ganeshan from the bike rack at Perry Mathers Hall. And February 16th of 2017, the bike was stolen from Zachary Matthews. The guilty plea was taken with special conditions, including that the defendant stay away from Georgia Tech campus and outside of it for a 4-block radius of that location. Your Honor, there is also an open felony case right now under on November 17th of 2021, the defendant stole a white and blue Giant brand bike, property of Shang Wu from Folk Residence Hall, by using a cutting tool to cut the cable lock securing the bike to the bike rack. Your Honor, this defendant has multiple cases of doing the exact same thing on camera to multiple different victims, while also being told to stay away from the incident location and 4 blocks from Georgia Tech's campus. So we think that in this case that there's a very high likelihood of reoffense. As he has an open felony case right now, Your Honor, we believe that there is a high likelihood that he could get another felony. So we do reiterate a $20,000 good bond on the theft by taking on the first case, and a $20,000 good bond on the theft by taking in the second case, and a $10,000 good bond on the criminal trespass in that second case, Your Honor.
All right, thank you. Ms. Armstrong?
Thank you, Judge. Just to first a little bit about my client, Mr. Oliver is homeless. He lives at a shelter right now. He does have a job though. He's been working at a restaurant, a fast food restaurant in the mall for about 3 months, and he has maintained that employment successfully. He washes dishes and he's part of the maintenance crew. And I am asking your bond to not set a felony bond in this misdemeanor case. I understand that the state's position, but we're talking about bicycles. I don't believe that it would be fair for the court to impose $20,000 bond on alleged theft of bicycles. And in reading the warrant, there will be issues concerning the identification of my client when it comes down to this going to trial. So given my client's financial situation, I am asking Your Honor to consider a signature bond in these cases. And if you're going to set a monetary amount, I ask that it not be more than $500 on each. Thank you.
All right.
Also, if I may, Your Honor.
Very briefly.
There are 14 cycles in Georgia. However, there are an additional 28 cycles of arrest in North Carolina to various charges, including felony larceny, forgery, fugitive charges, possession of stolen goods and property, breaking and entering, and multiple probation violations, Your Honor. Also, in the felony case that's open right now under 22 CP 214245, which looks to have been indicted under 22 DA 12040. He was issued a $20,000 good bond in that case. And we do feel like, Your Honor, that the only difference in these other two cases is the value of the bike stolen. So we do reiterate the seriousness of this charge and the fact that he will reoffend, Your Honor. And with him being homeless, Your Honor, it's very high likelihood that we're not going to be able to find him once he leaves as well.
All right, thank
I'm going to
you.
respond really briefly, Judge. The last part, he has an address. He lives at a shelter. That's the address on file. Thank you. So he will not be hard to find.
All right, at this time, in the case ending in 7962C, the defendant will receive a $7,500 good bond, $5,000 on the theft by taking, $2,500 on the criminal trespass. He is to stay away in its entirety from the Georgia Tech campus. The 4-block radius will continue to apply, and he's to have no contact with any of the victims. In the case ending in 7964C, defendant will receive a $7,000 surety bond. Same conditions, 4-block radius away from Georgia Tech, no contact with any of the victims. Is there anything further from either party?
No, Your Honor, you did say $7,500 good bond on the 1-count case, correct?
$7,000 on the 1 count. On the case with the 2 counts, it's 75, 5,000 count 1, 2,500 count 2.
Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Next, Your Honor, we have position number 6, Mr. Chase Staub.
All right, Mr. Staub, your case number is 22CR007966J. In this case, you're charged with 2 counts of making terroristic threats or acts and 2 counts of disorderly conduct with the offense date of November the 22nd. Do you understand your rights?
Yes, Your Honor.
All right, Ms. Harrison, can I have his history, please?
Your Honor, second arrest. First arrest was May of this year, reckless stunt driving in Dawson County, Georgia. No disposition listed on that arrest. He does meet the criteria for UJR pre-trial. Nothing further.
All right.
Good afternoon, Judge. Director Ekpo, on behalf of the state.
One second, Ms. Ekpo.
Sure, Judge.
All right, Ms. Ekpo, good afternoon. Please proceed.
Thank you, Judge. And I apologize. These facts are going to be a little long. And so I tried to make it as brief as I could, but there's a lot of information that we have on this particular case. He was originally charged with 2 counts of terroristic threats. We accused this case with 2 counts of terroristic threats and 2 counts of disorderly conduct. These are incidents that spanned over the course of a couple of days, starting on November 22nd of 2022. Officers responded to an incident location down in Peachtree and spoke with Mr. Brady Louvet, Loveaeau. He is a friend of the defendant's. He indicated to police that the defendant had been posting a bunch of disturbing things on Instagram, indirect threats, not just to the victim, but as well as to his husband. He indicated that the defendant had been showing up to his husband's job, trying to get his husband fired. He indicated that the defendant could possibly be suffering from mental illness, possibly schizophrenia. He stated that the threats have been not just towards himself and his husband, as well as towards the LGBTQ plus community, and that he is a part of that community. Those threats had been going on Instagram for about a week and a half prior to them alerting the police. The next day, on November 23rd of 2022, officers were then dispatched to a concerned caller who wanted a welfare check on this defendant. So this is the next day. The caller stated that the defendant had made unwelcome remarks on social media. What he did was he posted what appeared to be a gun and threatening to shoot up different LGBTQ plus communities and clubs. They wanted the police to check on the well-being of this defendant. Based on that information and the fact that it was on social media, the police and APD had to get Homeland Security involved. So Homeland Security coupled with APD, they show up to the defendant's house. They talk to him about those social media. The defendant was pleasant, according to the officers. He did give the officers the weapon that he had posted. It ended up being a non-lethal weapon. It was a pepper spray gun, but in looking at the weapon, when you post it on social media, it absolutely looks like it's a real gun. They also brought Grady EMS because at the time they thought that they were going to have to 713 him based off of how he was speaking to officers and how he was speaking to Homeland Security. They did not have enough information to 713 him. The officer spoke with him. Homeland Security advised him to stop making these threats on social media, especially what's been going on in our country right now, that this would not be the best thing for him to continue to do. And he indicated to officers that he would not continue to do that. However, it continued. They then respond later on that same day, November 23rd, to the Heretic nightclub, which is an LGBTQ plus community club. They meet with the owner and a party promoter who both advised that there were continuing threats that the defendant had posted on social media towards the LGBT plus community, basically saying that he was going to come up there and he was going to shoot up the nightclub for some unknown reasons. They then forwarded that information to the Homeland Security investigator who was gathering all of these social media posts and trying to make a determination if he had enough information to take out warrants. After meeting with the defendant, after multiple requests by the LGBT plus community to have this defendant arrested, what he ended up doing later on November 24th was he decided that he was going to post another fake story onto Instagram as if it was the New York Times concerning Club Heretic in particular being shot up. He also stated on his social media that Homeland Security had just come to his house earlier that day and he had passed all their tests. He posted on his IG account and basically had a live IG going and saying, play the podcast of how to get away with murder. And then he referenced going to jail and not being afraid to go back to jail. He stated that he had a list of names on, and he was hoping that whoever was going to mess with him that day, that you better hope your name doesn't get on my list. And he continued these messages all the way up until November 24th. November 24th comes around. He is still posting all night. So this is going from the 22nd, the 23rd, into the early morning on the 24th. On the 24th, the officers now get a fourth call from the owners of Felix Atlanta and Oscars Atlanta, which are also two additional LGBTQ plus communities, clubs. They have concerns about the defendant in regards to threatening phone calls that they had received that day, and also posts that he had been posting still nonstop from the previous day. The patrons advised the officers that the defendant had entered into Felix Atlanta, but they asked him to leave. He had then went next door to Oscars Atlanta, and he was asked to leave too. They indicated that that time there were no warrants, so they could not arrest him, and the defendant left without any incident. The next day, later on that day, after Homeland Security gathered this additional information, all the social media posts, they did apply for warrants, and warrants were issued and were granted on November 24th around 5:30 in the afternoon. So next day, here we are, day number 4, November 25th, there's a bolo out for this defendant. The officers know where he lives. They are headed to his house because of the bolo, they have the information. On their way to his house, they get a 911 call coming from the defendant's mother. She's about 2 hours away, and she indicates that she needs there to be a welfare check on her son, that she has overheard comments where he is threatening to shoot and kill his roommate, and that he was potentially suicidal. By the time the officers arrive on scene, the defendant comes out, he is smiling, he has no shoes on, and they arrest him without incident. Like they indicated earlier today, he does not have a criminal history, judge, but he is currently on bond for a reckless stunt driving from a May 8th, 2022 incident out of Dawson County. The state would be asking for a $25,000 bond on each charge for a total of $100,000 bond. We would be asking for a mental health evaluation. My understanding after speaking with the defendant's mother, one of our advocates spoke with his mom, that he is prescribed medication, but does not take medication the way that it's supposed to be described. And this may be a result from him not taking medication the way that it should be prescribed. We would ask that he have no contact directly or indirectly via social media or any third party with Brady Laveau, Loveau. Do not return to Club Heretic, Felix Atlanta, Oscars Atlanta, or any other LGBTQ plus club while on bond. He needs to surrender any and all weapons to the Fulton Sheriff's Office. He is to make no more posts on social media about any LGBTQ plus clubs. And if released, we would ask judge that he be released to a mental health facility. I understand that the state is asking for a very, very extremely high bond, but we have concerns about what may happen if he does get out on bond again, and we are not trying to address the underlying mental health problem. Thank you, Your Honor.
All right, thank you, Ms. Armstrong.
Thank you, Judge. My client is a homeowner. He's also a business owner. He's been in the Atlanta area for the last decade. Given his lack of criminal history, I'm asking Your Honor to set a bond that reflects his lack of criminal history and set a bond no more than the amount of $2,000 on each matter and impose any conditions as you see fit. Thank you.
Thank you, Ms. Armstrong. Give me one moment to do this now. Okay, on count one, the defendant will receive a $5,000 surety bond. On count two, he'll receive a $5,000 surety bond. On count three, he'll receive a $10,000 surety bond. And count four, he'll receive a $10,000 surety bond for a total of a $30,000 surety bond, I believe. Is that math? Yes. He is to have absolutely no contact with any of the victims alleged in this case. He is not to return to any of those listed clubs or any other clubs identified as an LGBT club, nor is he to post about those on social media. He is to have no alcohol, drugs, or weapons. He must surrender any of the subject weapons or any weapons he may have in his possession. Is there anything further from either party?
Not from the state.
All right, best of luck to you, sir.
Next, we have position number 7, Mr.
Can we?
Stevens.
All right, who do we have next?
That's it.
All right, Mr.
No.
Stevens. All right, good afternoon, Mr. Stevens. Your case number is 22 CR 007959A. In this case, you're charged with criminal trespass and damage to property. Do you understand your rights here today?
Yes.
All right, can I have his history, please, Ms. Harrison?
Yes, Judge, 13 cycles with history in Georgia and Wisconsin. Last arrest May of this year for criminal trespass and simple battery in Fulton County. That is an open case, 21 CR 002514A. Record also indicates an additional record indicates an open probation in Fulton County for criminal trespass and 2 counts of simple battery, 22 CR 002876A. Sentenced May of this year, 12 months probation and 30 days confinement. 1 failure to appear within the past 10 years and a 2019 disorderly conduct out of Wisconsin. Nothing further to add.
All right, thank you, Ms. Guidry.
Yes, Your Honor. The state is recommending in this case, he's charged with criminal trespass and damage to property. We're recommending a $7,500 surety bond, a stay away from 265 Peachtree Street, Northeast Atlanta. That is the Hyatt Regency, and no alcohol, drugs, or weapons. Your Honor, we would show that on November 25th of 2022, yesterday, the defendant arrived to Hyatt Regency. Officers responded to that Hyatt Regency in reference to a trespass call. They spoke to the security supervisor, Spurgeon, Spurgeon, Glenn, who informed them that guests were calling, stating that someone was trying to get into their room via connected door. When they arrived to that door that was supposed to be unoccupied, they noticed that they could not get in. They attempted to get in, but they were later confirmed that something was in the door jamb so that they could not get in. They left, and then when they returned, the defendant was walking out of the room. They entered the room with the defendant when they noticed that the defendant had totally trashed the room. The room was damaged, an iron was damaged, a remote control, a mirror, and they also observed broken glass inside of the room. The defendant was then placed in custody and transported. Your Honor, given his criminal history, as pretrial has stated, he does have an open case for theft by shoplifting for May of last year, and he was just found guilty or pled guilty to a simple battery, 2 counts, and criminal trespass this year. Your Honor, that criminal trespass occurred at 265 Peachtree Center Avenue at Marriott, which is pretty similar to this case. They're pretty much the same exact facts. He entered the Marriott Marquise Hotel and was walking around with a bucket. That time, he didn't try to enter anyone's room, but this time he did try to enter into the rooms of others occupying the hotel. Your Honor, we are concerned for the safety of others, given that he continues to enter into these hotels to get into the rooms of others occupying the room. So he does have a risk of reoffending, given that he just was arrested this year and found guilty this year for the exact same thing. He is a flight risk, given that he does have a failure to appear for that theft by shoplifting from last year in October. And on his Wisconsin criminal history, he does have 2 trespasses, one from 2009 and one from 2012. They were dismissed, however, they are pretty relevant to this case as well, given that he was trespassing in buildings in Wisconsin as well. Lastly, Your Honor, on his Wisconsin history, where he has 10 cycles, he has a bail jumping charge from 2012. So he is likely to fail to appear. So we are concerned for his safety. We're concerned for the community safety, and that he continues to enter into these hotels.
All right, thank you. Ms. Armstrong?
Judge, my client is unemployed. My client is homeless. I ask you set a bond no more than $1,000. Thank you.
All right, defendant will receive a $2,000 surety bond. He is to stay away from the address on Peachtree Center and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state.
All right, best of luck to you, sir. Who do we have next?
Position number 4.
Your Honor, what was that bond amount? I'm sorry, I have an issue with position number 2 in here.
2,000. Do you want to go back to position 2? Has he spoken to Mr. Bartell so that we could be
I
done
don't
with
know
that?
if he finished, he just hung up the phone. So I don't know what's going on, really.
Your Honor, I have spoken somewhat with Mr. Cade. I think I'm ready to proceed on that case, but I would ask to go into a breakout room with the court and the state.
Okay, can we go in that breakout room? I believe Ms. Williams, Ms. Ekpo will probably need to be there as well.
That's
Mr.
correct.
Bartell.
Come on, man. You absolutely right.
All right, waiting for that breakout. All right, the defendant will receive a $9,000 surety bond, $4,500 on each count. He is to undergo evaluations as discussed in breakout. He must stay away from the address on Lake Drive and have absolutely no contact with Ms. Harris. Is there anything further?
Nothing
All
further
right.
from the state.
Nothing further from defense, Your Honor.
All right, best of luck to you, sir. We can go to the next position.
Position number 4, Judge.
All right, good afternoon. Are you Brandi Masters?
Yes, Judge.
All right, Ms. Masters, in this case, 22 CR 007963H, you're charged with 1 count of driving under the influence of alcohol, less safe, 1 count of reckless driving, and 1 count of simple battery with the offense date of November the 25th. You have an absolute right to remain silent. Anything you say can and will be used against you. Also, this proceeding is being broadcast over the internet as a live stream. It's also being recorded. Do you understand all of that, Ms. Masters?
You, Judge.
All right, thank you. Ms. Harrison, can I have the history, please?
Yes, Judge. 6 cycles. Last arrest December of 2017 for willful obstruction of law enforcement officers and simple battery in Fulton County. Record indicates that's an open case, 19 CR 002182A. It is in dormant bench warrant status. Record indicates a 2017 DUI under case 16 CR 00425J. 2014 DUI, which was no pros. In 2014, she was arrested for DUI, reckless conduct, and failure to obey traffic signs. She was convicted on the failure to obey traffic signs, and the DUI and reckless conduct was no pros. 2014 DUI and a 2001 DUI. Nothing further.
All right,
Mayor Williams for the state, Your Honor.
all right, Ms. Williams. All right, please proceed.
The state is asking for a $10,000 good bond on the DUI less safe, a $2,500 good bond on the reckless driving, and a $2,500 good bond on the simple battery. The defendant does have, the state is showing 8 cycles total in Georgia and 3 cycles in Florida with convictions for DUI in both 2001 and April of 2014, where the September 2014 arrest looked to be non-pros. And there was also a 2008 DUI arrest as well that the state is showing on the GCIC. On yesterday, 11/25, Your Honor, APD Officer Jeffrey was dispatched to the area of 248 Far Road to assist with an intoxicated driver stopped by another officer, Officer Ruddock. And after making contact with the defendant, he did observe a strong odor of alcohol, bloodshot, and glassy eyes. The HGN was 6 out of 6, but the defendant refused to do the walk and turn in the preliminary breath test. She also attempted to sit in the middle of the roadway while being walked to the patrol car by the officers. She was read implied consent for breath and refused, and subsequently spat in the face of Officer Jeffrey. She was subsequently arrested, Your Honor. With regard to her history, strong likelihood of rearrest, especially for DUI and for the safety of the community. We do think that an elevated bond of $10,000 on a DUI is warranted, Your Honor.
All right, thank you. Who represents this defendant?
Erin Donnelly from Scott Smith's office.
All right, Ms. Donnelly, please proceed.
Yes, Your Honor. My client is not a risk of flight. She is from the state of Georgia. She has a home in Fulton County. She has a 1-year-old child as well. And she does have family support. She also has gainful employment working at a steakhouse in Atlanta. My firm has worked with her in the past on these DUIs, and it sounds like the only 2 convictions she has are back in 2001 and 2014, as the others were null pros. The only history she's had in the last 5 years is back in 2017. Doesn't sound like she has any felony arrests. And we are representing her on the simple battery as well as the DUI. And so we will ensure that she shows up to court when required. She also does have a bench warrant that they stated, and that is in Judge Ross' court. And I will be there on Monday, and I do believe that that will be lifted. And so I am asking for a reasonable bond in this case. And I think for the DUI case, a 1,500 good bond, and on the simple battery, a 1,500 good bond.
All right, thank you. At this time, the defendant will receive a $7,000 surety bond, $5,000 on the DUI, $1,000 on the reckless, $1,000 on the simple battery. She's not to drive without a valid license issued by the Georgia DDS, and she's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing from the defense, Your Honor.
Nothing
All
further
right.
from the state, Your Honor.
All right, best of luck to you, Ms. Masters. The only position we have left now, oh, you can be excused, Ms. Donnelly. Have a great rest of your afternoon. All right, the only position we have left is position 3, the case of Quintavious Dupree.
7,000. Sure. Yeah.
Judge, I saw in the chat that the PD had asked to reset this to a competency calendar. Mr. Bartel?
We still have to
That's
set a
good.
first appearance, though. They still have to get an initial bond, even if we, even if that's the case and you're asking to be reset there, we still have to, he still has to appear. So is he not at the jail today?
I've advised he's on lockdown, Your Honor. He's on 7 board.
Did you,
He's here at the jail. I took the phone upstairs. I tried to have Mr. Paul Bartel talk to him. He's really not cooperating at all. Mr. Bartel heard it for himself.
Well, and we have Mr. Howard from our office did submit a proposed order for a competency evaluation. I think that would be appropriate in his case as well. So we would just ask that as with Mr. Cade, that an appropriate bond be set.
well, the problem is without a valid waiver of his appearance, I can't even set that initial bond. And if he won't talk to you, you can't waive his appearance.
Well, then maybe I would, the evaluation order has already been submitted. So with the bond, I would just say it could be reset to Monday.
All right, that's unfortunate. If not, if we can reset him to Monday, and it's our hope that maybe you can get him to waive his appearance so that a bond can be set for him on Monday. All right, do your best, Mr. Bartels. I appreciate it.
Okay.
I believe that concludes the entire calendar.
It does, Judge. May I ask just one question for clarification, if Your Honor doesn't mind?
Sure.
Position 6, did you order a mental health evaluation, Judge? I couldn't recall if you had said that.
I did not at this time.
Okay.
All right, Ms. Grace, will you review the entire calendar for us, please?
Add-on calendar, position number 1 is a $7,500 good bond. Regular calendar, position number 1 is a $1,000 pretrial bond. Position number 2 is a $9,000 good bond. Position number 3 is reset 11/28 SCA calendar. Position number 4.
I'm sorry, is there also a reset to the competency calendar for number 3?
For who?
For number 3, Mr. Dupree, there should be a reset.
No, we're not resetting that there yet, Mr. Bartels. We're gonna still have him come to first appearance. He has to get an initial bond first appearance before I can put him on a competency calendar. So we'll put him on Monday's SCA, and then from there, if he continues to be reset, then I believe we'll be able to do that. How many times has he been on this calendar? Is this the first time?
I think this is the second time.
Okay, so we will reset to Monday, and I believe Judge Law will be presiding then, so I'll speak to her about this case.
And position number 2, that was reset to the competency calendar as well with the $9,000 good bond, correct?
No, that was reset 12/8.
He was present.
Yes, the judge said that there was a competency calendar on that date.
Yes, that's correct. I'm sorry, 12/8, competency instead of SAP. Same calendar, essentially.
Okay.
Number 1, was that a $5,000 signature bond? That's what I have down.
Oh, God.
Or 1,000.
I've got 5,000.
I have 5,000.
It was 5.
Okay.
Position number 4, $7,000 good bond. Position number 5, $7,000 good bond. Position number 6, $30,000 good bond. And position number 7, $2,000 good bond.
Are there any other comments, changes, questions, or corrections? All right, hearing none, we will be in recess until Monday's SCA calendar. And I will reach out about that position 3. Everyone take care and enjoy the rest of your weekend. Bye-bye.
Hey, Judge.